we're off the record right now. First question I have is whether the parties have had an opportunity to talk about a proposed schedule or not.
Yes, we have.
We have not been involved in any discussions on the schedule.
Okay. And who are you, ma'am?
I'm Christine Lang.
Okay. I want to inform you that you're not a party to this
Okay.
proceeding. You need to intervene if you choose to be a party.
Okay.
Your complaint by itself does not, or your notice to the board does not initiate a party status. You have to formally seek that pursuant to Board Rule 2.209. That doesn't mean you can't talk about scheduling with people. Quite often the board treats people who may intervene as parties prior to that judgment being made for purposes of scheduling. So,
I'm sorry, sir, I can't hear you.
Yeah. Thank you.
okay, can you hear me now?
Thank you, yes, thank you very much.
Okay. Can you provide a copy of the proposed schedule to Ms. Lang?
I don't have a proposed, we've discussed it. I don't have anything in writing other than my notes.
Okay, yes.
Excuse me, yes, I'm Representative Mariana Gamache. I represent Swanton and Sheldon, and I would also like to have a copy of the schedule when it is set.
Okay, great. Why don't we, so what you have developed is with the department
And the Agency of Natural Resources.
and
yes.
Agency of Natural Resources. Okay,
Yeah.
great. Why don't I leave and come back in 10 minutes and give you the opportunity to discuss that with all the parties, with Ms. Lang and the others.
Well, I actually think it would be better for us to do that on the record, please.
Okay.
Thank you. And let me explain that the schedule did not contemplate motions to intervene because this is a Section 209, Section 30 proceeding.
Right, and I'm not certain whether or not intervention would be granted, because quite often in Section 30 proceedings, intervention is not granted. But I did want to make sure Ms. Lang knew that that would be a procedure that she would have to follow in order to do so.
We're on the same page.
Okay, great.
We do want to intervene and we want to present evidence.
Okay, well, that you may or may not be allowed. Quite often in Section 30 proceedings in which you have no direct involvement, you may not be granted that. And there are a couple of recent examples where the board has not granted intervention. Most specifically, the one that comes to mind is in the investigation into the Vermont Gas System's failure to report under Board Rule 5.409. In that case, CLF and I forget, it might have been AARP were denied the opportunity to intervene.
So if we don't intervene, how do we present evidence?
Can we do this on the record?
Sure, I think we will, especially since we're on the record anyway. Let's go ahead and go on the record then. Good morning, I am Mike Towsley and I am serving as the hearing officer for the Public Service Board, which in this case is an investigation pursuant to 30 VSA sections 30 and 209 regarding the construction and operation of a meteorological tower located in Swanton, Vermont. The board docket is 8561 for this case. We are together today in Montpelier to conduct a pre-hearing conference. First, I'd like to take appearances, so if you could state your name, and your affiliation with this matter, then I'll summarize the off-the-record discussion that we just had.
Megan Ludwig for the Vermont Department of Public Service. In the room as well is Jeff Common, the Director of Public Affairs. Jen Duggan, Agency of Natural Resources.
Representative Mariana Gamache from Swanton and Sheldon.
How do you spell your last name, ma'am?
Gamache.
Christine Lang, I filed the complaint.
Annette Smith, Vermonters for Clean Environment.
I'm sorry, could you repeat that?
Annette Smith, Vermonters for Clean Environment.
Patricia Rainville. I'm a neighbor to this project.
How do you spell your last name, ma'am?
Rainville.
Allison Milbury Stone, the legal counselors and advocates, and working with Leslie and representing Travis Belisle.
And Leslie Cadwell, legal counsel and advocates on behalf of Travis Belisle.
I'm sorry, ma'am, I didn't get your full name, your last name.
Stone,
Okay.
Allison Milbury Stone.
Okay, we had a brief discussion off the record before we went on the record. During that discussion, we talked about a couple things. One of them is Ms. Lang's desire to intervene as a party.
I'm
Excuse me.
Christine Lang's husband. My name is also on that committee.
Okay. And what's your name, sir? Your first name?
Dustin, D-U-S-T-I-N.
Excuse me, I would like my name on, I would like to speak today too.
Okay. Well, let me just stop now and say this is not a public hearing. Okay, this is a pre-hearing conference at which a schedule for the proceeding is established. So I'm not going to be developing any evidence. This isn't an opportunity to talk about how this might impact you per se. This is really just to set a schedule for the proceeding. Do you understand?
We'll be back.
Is there anyone else who wishes, I'm sorry, ma'am, I didn't get your name.
Penny Doobie,
How's your last name spelled?
D-U-B-I-E.
Is there anyone else who wishes to be recognized on the record? Yes, ma'am.
Danielle Garrett.
And what are your relations to Ms. Doobie and Ms. Garrett to the project?
I'm a neighbor. I'm a joining landowner.
Again, this isn't the 248 proceeding into a petition to build a wind turbine. This is an investigation into whether or not there is a Met Tower, whether or not that Met Tower received a CPG before it was constructed, and if that's the case, whether or not the individual who owns and constructed the Met Tower should be fined pursuant to 30 VSA Section 30.
We understand.
Okay. And I say that because the role of adjoining landowners, et cetera, can be quite different in a 248 proceeding than in a Section 30 proceeding. And the amenability of the board to interveners is different for that reason. We also, along with talking about
Did you get my last name?
G-A-R-R-E-T-T?
G-A-R-R-A-N-T.
A-N-T, I'm sorry.
Thank you.
Also, during our chat off the record, we talked a little bit about potential schedule, and Ms. Cadwell, you indicated that you had developed a schedule with A&R and the department. Could you describe that, please?
Yes, and I'd like to caveat that with, by saying that there probably should be a period for a motion to intervene that can begin today. But we talked about providing testimony and under oath from the respondent by September 14th. Have a period of discovery, rolling discovery through the 12th of October, with a report back to the hearing officer on next steps, whether there will be a stipulation of facts and briefing under the criteria of Section 30, or whether additional factual development in a hearing is necessary. But that we file something by October 30th with the hearing officer for those next steps. In terms of intervention, you know, I'm happy to have, you know, a reasonable response period under the rules. I think Rule 78 provides for a 15-day period for responses to motions, and if that's what the hearing officer would like to adopt for the purposes of accommodating the folks who want to seek to intervene, that would work for us as well.
Okay. When you talk about rolling discovery, what do you contemplate?
Really the idea is to give the department and the Agency of Natural Resources the information that they need in a timely way. So it is, they can issue requests and we respond within 10 days. My goal is to have enough information filed on the 14th that there won't be that many questions left. But I've talked to both counsel for A&R in the department, and our position is that they have a responsibility to develop the facts, and I want to help them do that. So if it turns out that additional time after the 12th is needed, we'll work together to make sure that they get the information that they need.
Okay. Okay, I have two dates written down on my little piece of paper here.
Yep.
One of them says September 14th, and that what I have there is pre-filed testimony.
Correct. I'm going to do the pre-filed testimony with an affidavit, however. Normally, as you know, the pre-filed testimony comes in
And that would be
without an
Mr.
affidavit.
Belisle.
Correct.
Okay. And then I have the date October 12th on my piece of paper here. And then it says rolling discovery. And what I think I understood you to say is that from the period of September 14th, when the pre-filed testimony was submitted, through October 12th, the petitioner would engage in rolling discovery with the department and the agency.
Correct. And I anticipate, you know, whatever, talking with them about what additional information they might want in the original pre-file to try to limit how much work they have to do to ask questions later.
Okay, when you talk about rolling discovery, what you contemplate is that once pre-filed testimony is submitted, that questions will arise from the agency and the department and any other parties that are deemed parties at that time.
Correct.
And that you would answer them, and there might be a couple of rounds of questions and answers.
Correct.
Okay.
Correct.
Can I just ask for clarification? Is the 10th contemplated as the last day on which we can ask discovery, or
The 12th?
Yes, the 12th, I'm sorry.
Well, I had in mind that we would give you everything by the 12th, but if you have in mind that that's the last day, that's fine with me.
Okay, I would prefer that.
That
just,
works. That's fine. So it would be the
understanding
last
that it may
day.
be complete well
Yep,
before then, but-
yep. So the last day, we'll use October 12th as the last day to propound discovery,
Okay.
under the tentative schedule with a report by the 30th of October. So you should have 3 dates.
Oh, okay, so what's October 30th?
That is a report back on next steps.
Oh, okay, yeah, I do have October 30th here, and it says, what I have stipulation October 30th, but stipulation or other.
Correct.
And other could include a technical hearing, conceivably followed by a penalty hearing.
Correct.
Okay, okay, so, yes, ma'am. Ms. Gamache.
So this is my first hearing. So I understand what is being said, but I kind of got lost at some point. With the dates as they're being set, I understand the concept, I'm not exactly sure what those dates represent in terms of input, in terms of the procedure.
Sure.
It's a little legalese for me.
Sure. Okay, on September 14th, what Ms. Cadwell proposes is that, and again, these are not set dates. I will set the dates once I consider the input of the parties. But on September 14th, what Ms. Cadwell has proposed is that Mr. Belisle would submit pre-file testimony with an affidavit. Effectively, he would say what's going on and swear to it in a document. Okay. Based on that, any of the parties, which in this case include just Mr. Belisle, the agency and the department, and the department as non-responding parties would have opportunities to ask questions to supplement the information provided in Mr. Belisle's pre-file testimony, and that would occur in potentially 1 or 2 rounds. Basically, the department may have some questions about what Mr. Belisle said. Mr. Belisle's counsel and Mr. Belisle would answer them. Then that may lead to another round of questions that would be asked and answered, and that discovery period, that seeking of information, would be concluded by October 12th. Okay. Then on October 30th, what Ms. Cadwell proposes is that Mr. Belisle would propose a schedule of next steps, which can either be a technical hearing at which the parties would present evidence, or it could be a stipulation, which is an agreement between, if in fact there are just the 3 parties at that time, an agreement between the agency, the department, and Mr. Belisle as to what the facts are, such that a hearing would not be necessary to establish those facts, and they would accept the facts as written, okay, in the stipulation. So that's what happens on October 30th. It would either be a proposed schedule that would include a technical hearing at which evidence would be developed, or it would be a piece of paper in which the parties agree that this is the evidence. And then I could either accept or reject that stipulation. Okay. Then after that, if there's a technical hearing, we would come back here and the parties would have the opportunity to present evidence into the record in a live fashion, either by submitting documents or by providing testimony. And I could ask questions, the other parties can ask questions if they are live witnesses that are providing testimony. Okay. That has not yet been scheduled, and that would be scheduled sometime in November. Okay. Likely, given at least what's proposed now. Okay. And then after the technical hearing or the stipulation, if in fact there is a stipulation that I accept in lieu of a technical hearing, I would craft what's called a proposal for decision, which is my decision, my determination based on the facts as they have been developed in the record, and my recommendations to the board, which would make the final determination as to what the facts are and what, if any, penalty would be assessed under 30 VSA Section 30. And that would occur basically when my proposal for decision goes out. The parties would have an opportunity to comment on that. The board will consider those comments as well as my proposal for decision in its making of its determination, which I'm guessing would take place probably sometime after Thanksgiving. Yes, ma'am.
You speak of
Could
the
you repeat
parties
your name
anyway.
again, please?
I'm sorry.
Could I have your name again?
Patricia Rainville. You spoke of the parties as being the agency, the department, and Mr. Belisle.
Yes, ma'am.
Where do the citizens come in?
They can seek intervention.
When?
We have not yet established those dates.
Okay, but why?
But I will do that as part of the schedule today.
Okay, because my question is, why wouldn't the citizens have equal input as the agency, the department, and Mr. Belisle?
Because you have to articulate a substantial interest in the proceeding under Board Rule 2.209. and the board has the discretion to either accept or not accept non-party members, intervening parties. They can and they can't.
What gives you the discretion to eliminate the citizens from the process?
The law does.
We need to go to the legislature.
And Board Rule 2.209. That doesn't mean that you will be, but you could be.
We
It
need to-
depends on whether or not you have substantial interest that will impact the ability of the board to make its decision. Yes, ma'am.
Representative Gamache again. So I need a little clarification.
Yes, ma'am.
The homeowners who are going to be directly affected by this project, am I understanding that their
Well,
testimony?
this proceeding is not addressing a project.
Down the road.
That's a different
The
proceeding
intervention.
at which the homeowners could participate in that proceeding as interveners. This proceeding is purely to address whether or not a penalty, whether or not there is a Met Tower, whether or not it was built pursuant to a CPG or not, and if not, whether a penalty should be forthcoming.
I understand that. I was trying to get clarification for Mrs. Rainville's question.
Sure.
And so I myself am not clear on at what point in this process the homeowners that would be impacted by this project would be able to give testimony. At what point in this procedure?
In this procedure, not at all.
I'm
Not
sorry,
in this
I'm saying this procedure.
In the Section 248 proceeding,
Right,
it would
that's
be, if, basically what happens, and I described, the discovery and the
Yes.
pre-file testimony and
Mhm.
discovery and stipulation. If a party is, if a neighbor or a member of the public is granted intervening status, they can participate in those elements of the proceeding and provide testimony conceivably as part of the discovery, as well as at the technical hearing if one should arise, in the 248 proceeding.
Okay, so that would be in the beginning of the 248 procedure?
Not in the beginning, it would be more towards the end. They
That's
they would
exactly
intervene in the beginning.
Okay,
and then-
so I am not clear on at what point the homeowners and under what circumstances the homeowners can be involved in intervening and giving testimony.
They can be involved in the Article 248 proceeding that would be related to a petition to build a wind tower, okay, which isn't what this is.
I understand that.
In that proceeding, just as we are here setting a date for interveners in this proceeding, a date would be set at the pre-hearing conference for intervention in that proceeding as well. So that would set the date for intervention if adjoining landowners, if people seeking intervention, meet the criterion set in Board Rule 2.209 and are granted intervention, then they would be able to participate throughout the proceeding, both during discovery and in the development of a stipulation or at the technical hearing.
What is the criteria for granting intervention? Because I do not know.
It's, it's set in Board Rule 2.209, and effectively it's whether or not the individual has articulated a substantial interest in the proceeding, such that the board believes it's permissibly appropriate to allow them to intervene.
See, that's where our problem is. Because if the agency, the department, and Mr. Belisle have
They're-
full in,
They're in
Why
because
is
of
it the city?
statute. Mr. Belisle is in because he is the subject of, his activities are the subject of the investigation. Okay? The agency and the department are statutory parties to all board proceedings. That's why it's different. Yes, ma'am?
I just want to clarify, actually,
Yeah.
the agency is not a
Right.
statutory party to all board proceedings. The Department of Public Service is actually a statutory party to all board proceedings. The agency is a statutory party in proceedings in Section 248.
Right.
They've intervened here, and we have,
Yes.
or they have appeared here, and we have no objection to them participating because they do represent the interests of the people of the state with respect to the protection of the natural
And the
environment.
board would be interested in their expertise in that regard.
I just wanted to clarify.
No, you're right, there is a distinction between the department and the agency.
I'm confused because if I hadn't filed a complaint, you would not even know about this issue, and yet.
This is not a civil court, ma'am.
But I'm
You're not a petitioner in a civil court. This is a utility regulation proceeding under Title 30, which means that the board is primarily interested in the activities of those people who, like Mr. Belisle, who have conducted activities that impact the regulations that the board oversees.
And if I have facts to support things.
Then you can seek to intervene. If you can articulate a substantial interest, then you may be granted intervention status. But you're just not, you don't have it automatically, like the other parties kind of do. Okay? Yes, ma'am.
Danielle Garrett. How are you supposed to articulate that you want to intervene if you're not allowed to speak first? Like, when are you allowed to say that I have
You can set, when we set the date for motions to intervene, you can write a letter to the board, a motion to intervene, telling them why you think you should be an intervener pursuant to the criterion that are articulated in Board Rule 2.209.
Are you saying that we should just trust you?
That is, ma'am, I'm
Yes,
telling you,
it is.
not at all what I'm saying. What I'm saying is that there's a procedure that's involved in this, and the way that you get to intervene is through Board Rule 2.209. It doesn't mean that that's foreclosed, that's just how it works.
So we're not about to accept the sentence, it's just how it works, because we are interested, we are involved.
Well, then
And
you
we're
want
not here, and we're not here just for us, we're here for the people in the state who aren't aware of this going on, like we who didn't have it in our backyard weren't aware of the issues that the people in Lowell and people in the other places that had this happen. They found out about what was going on when it was too late to do anything, and we're not going to let that happen for us, and we need to be heard early in the process so that we can do something to help the people who had this happen to them without any say that was heard. We are here, and we are here to stay.
And I'm listening, ma'am.
Good, you need to.
Okay. We talked a little bit about a potential date for motions to intervene. I think what you suggested was something 15 days from today.
Well, I was saying that whatever you think is appropriate, I will respond within 15 days,
Okay.
under Rule 78.
Okay, today is August 25th. We have a 3-day weekend in a couple of weeks. I think what I'd like to propose is that the deadline for motions to intervene be prior to the Labor Day 3-day weekend on Friday, October 4th, or September 4th. So deadline for, unless the parties have a better idea, I'm just tossing that out, and then that responses to the motions to intervene would be due on Monday, September 21st. Any comments?
That works for me.
That's fine.
Great.
So we want to make sure that the decisions on the motions to intervene are made before discovery starts.
Why?
So we can participate.
Okay, well, if there is intervention, the discovery schedule would be modified. We can set a schedule now with the proviso that it may be modified based on the status of any interveners. Okay, so I think I would like to continue with, and arguably what that means is that on September 14th, Mr. Belisle will submit testimony. That's all that really means. And that after that point, sometime after September 21st, if there is intervention granted, that we would modify the schedule to extend it for discovery based on the determinations as to whether or not people are granted intervention. Okay? Did you, does that
I'm
make
good.
sense? You're
Yep,
good? Okay.
absolutely.
Okay. How about a site visit? Did you talk about a site visit?
Only if it's during good foliage.
Well, yeah.
Would you like a site visit?
Yes.
Well, there we go. Let's have a site visit.
If I can just interject,
Yes,
I'm
ma'am.
only able to attend the site visit on Tuesdays and Thursdays.
Okay.
So I would request that it be something on Thursday.
Okay.
And we support that.
Okay.
Excuse me?
Yes, ma'am.
I'm fully in favor of a site visit, just to let you know. But I do think the sooner the better. I don't think it's particularly advantageous to wait for full.
Let me inform you what the purpose of the site visit is. The
Yes.
purpose of the site visit is for me to see the site.
Yes.
So I can relate to the board the nature of what I'm talking about when I make my recommendation.
I understand that.
Okay. That doesn't mean that neighbors can't participate and et cetera, but it isn't a public hearing, it's a site
No,
visit.
I understand that. I'm just giving my thoughts as to the time of the year in terms of
Oh.
foliage or not.
I think that was just trying to lighten the atmosphere here a little bit.
Perhaps.
I mean,
I think it would make sense to have a site visit after the testimony, so sometime after September 14th would be my suggestion.
yeah, then we have a little more effects. Okay, that
Exactly.
makes sense. Okay, September 14th is Monday. Ms. Ludwig, why don't you look at your calendar and see if you're available either the 15th or 17th of September.
I'm available on the 15th. It would be my preference if we could schedule one for early afternoon.
Okay. It may be better to schedule it even after, just to make sure that we actually have the pre-file testimony in hand and have had an opportunity to review it before going out to the site.
Okay. I've been informed by my colleague, Mr. Commons, that he'll be able to attend if I were not able to. So that opens up many more possibilities.
Okay, great.
So I will.
I would like to do it sometime that week of the 14th. The 15th might be a little bit too soon because we might not have it in hand yet. I would suggest the 17th or
I
the
will say
16th,
it's
17th.
possible that for that particular week, the 16th may be possible, and normally Wednesday, the 16th may be possible for me. Otherwise, I
Okay.
or the 17th, and he may be available to
Okay.
attend.
Start?
The 16th would work for me also, the 17th as well.
Okay. Schedule?
I just need to check with my client. It will work for us. I can confirm if I don't think it'll be an issue, but.
Okay, we'll put both dates out there, preferably the 16th.
16th or 17th, the preference on the 16th?
Yes,
Okay.
ma'am.
Yep. And I should be able to get back to the board, through the clerk's office on the right date today, even later today or tomorrow morning. And I'll also, just while you're thinking, coordinate meet location.
Please.
And other requirements for
Okay.
folks that are going to attend.
Okay. Okay, so it looks like, let me see if I can set these in chronological order now. Okay. What I have, and please correct me if I got the dates or the characterization incorrect, is September 4th is the intervention deadline. September 14th would be the beginning of discovery and the filing of pre-filed testimony by Mr. Belisle. September 16th or 17th would be a site visit. And we would probably do it in the afternoon, one of those days. Probably later afternoon, more like 3 or 4 o'clock.
Does that work for your meetings in the late afternoons? I'm sorry.
Doesn't have to be, that's just because I,
We'll make it work.
Okay, all right.
I mean, if you need to be there earlier, we can do that. That was just my pure whim to do it later, so that I can end my day with that event.
Okay.
I don't have to come back to the office if I end at 3 o'clock. Then September 21st is any responses by the petitioner or other parties to the intervention, any intervention requests. October 12th, ending of the discovery period with the caveat that that's subject to modification based on any needs of interveners, of any intervention granted. And then October 30th, what I have is proposed sched, which could be a stipulation or a litigation schedule. Does everybody understand what I just stated? Okay. I see heads nodding. Good.
Can I ask a question?
Yes, ma'am.
My name is Mary Ann Dole, I'm a neighbor. Just for clarification, I'd like to know, on the motions to intervene, is that just on the submission of the paperwork on the motions, or is there going to be testimony at that time by the people seeking intervention?
It's a paper motion.
Just
There's
simply
no
on-
testimony.
Okay.
You can describe what you want to say and why it might be valuable to the board,
Okay.
such that you can develop your substantial interest.
Okay. I just want to clarify for all my neighbors and people that came today.
Yeah.
Thank
In
you.
order to make that determination, there needs to be some factual basis or, for the board to make that substantial interest determination.
Strictly on what's been presented as an intervention.
Right, it's based on the representation of the party,
Thank
of the
you.
individual. Other questions? Okay, Ms. Smith.
Well, I have a question, like, a couple housekeeping items.
Sure.
First is, I've requested from the clerk of the board, and I don't know whether you can help me with this, actually get a copy of the file. The notice and all that went to my client. I entered an appearance, and all I have are the correspondence that I got from the department and from the public service. I don't know what else is in the board's file, and I've not received any documents from the clerk.
Okay, let me tell you what I have.
I'm happy to go
Let me tell you what I
upstairs.
have, because you may have the same things.
Perfect, okay,
Okay, because there isn't that much yet.
okay.
What I have right now is a letter from Mr. and Mrs. Lang dated July 6th. Okay, a board memo from the clerk of the board to Mr. Commons and to the Agency of Natural Resources asking for information and for the department to do an initial look as to what may or may not, how they responded to the Lang's concerns. And then we have, and that's dated July 8th, and then I have Mr. Commons' letter of July 23rd responding to that board memo. Okay. Then I have Ms. Duggan's request to make an appearance dated August 24th. I'm sorry, but before that I have Ms. Cadwell's request to make an appearance and notice of representation dated August 14th. So those are the extant documents that exist in this file as far as I know.
That's why I haven't heard from the clerk's office then. We're good. The only other housekeeping item is just for the benefit of the parties who aren't familiar with the rules, who would like to intervene, to just let them know how to actually file something and how many copies to give you.
Thank you, I was just going to ask. So, thank you.
You're welcome.
It's because I'm not there yet.
Sorry.
It's in the script here. Are there other matters, or should I use that as a segue to getting back to the script?
I'm done. Thank you.
Okay. Generally, since the board rule 2.204 usually requires that the parties provide an original and 6 copies, but since this is before a hearing officer, an original and 3 copies is normally sufficient. Filing under the board rules is paper filing with the clerk. The board does receive and appreciates email filing, but the official filing is the paper filing that's done with the clerk. And it would be an original and 3 copies with the clerk. And then you also would want to, if you're going to participate or seek to participate, I would recommend, so if I were an intervener, what I would do is create an original and 3 copies of my motion to intervene, send it to the clerk of the board, as well as to the department, the agency, and to Ms. Cadwell. So you're talking an original and 6 copies, 3 of them going to the existing parties, and the original 3 going to the clerk. Yes, ma'am.
Is there some guidelines such as the local rules or anything on which to do that, where it's in writing or a website that we can go to?
You can look at the board's website, which articulates, which you can link to the board rules.
And do you have that? Does anyone have knowledge of that site right now?
Yeah, I can give it to you, Mary Ann.
Thank you.
Yeah.
Okay.
I'd just like to add, if electronic filing is accomplished as well as the paper filing, that the parties, the department and A&R and counsel for Mr. Belay are copied on that email as well.
All right,
Right.
this is what I want to make sure to get it all for the folks who want to.
There is no board rule with regard to email filing because the board doesn't formally recognize email filing yet. We will be once we're developing a new technology that will, everything will be by electronics, but right now it's all by paper. So generally what occurs with regard to email filings, and it could occur right now, is that people share email addresses so that when you make a filing, you copy the other interested parties.
Thank you, Leslie, I look forward to getting it.
And just for one clarification, only because I know Mary Ann has lots of experience in federal court, the mailbox rule doesn't apply, so the filing is actually has to be at the board, at the clerk's office the day it's due.
This is why I need to know deadlines, because we have the local rules in the federal court. I retired from the U.S. District Court, and I know we need to
Yeah. really
stick with what you need.
I can give you what you
to get it done
need.
in a timely fashion, and to make sure that it's represented correctly. Thank you. Thank you very much.
Other questions? Okay. Are there any other matters that we need to take up before we adjourn? From the department or the agency? Any negatives? Ma'am,
I would like to read what I have brought for your information.
and what is it?
It's a description of why we're here.
Sure, go ahead.
Okay. Travis Belisle, David Blittersdorf, Martha Statkis, and Aeolian, I hope I pronounced that right, Renewable Energy, all have the same dubious distinction.
I'm going to object, I appreciate that you want to hear, but if what is going to happen, this proceeding is going to turn into ad hominem attacks against people who aren't present, I would respectfully request that the hearing officer provide them the opportunity to provide those comments in writing.
How do you
rather-
know what's on this
Ma'am,
paper?
ma'am, please.
Rather than take the time here for folks to listen to ad hominem attacks on the record.
Yes, ma'am.
Your Honor, could it be such that if Patricia Rainville continues in this fashion, could she just delete the names and give you what she'd like to present to you without names or attacking certain individuals, just the body of what the point is here?
Yeah, ma'am, I think what I'd like to do is just accept what you've written and I will read it.
No, I want to read it because I
Okay,
know
well then I'm
emotion
not going to
matters.
allow you to do
You
that
need
because
to-
that's not the purpose of this hearing.
You don't have any idea what's on this piece of paper.
Patricia?
If I could just
I had speak
add
by myself, thank you.
And if you file a motion to intervene, perhaps it would be appropriate for you to provide that then as well, to support your substantial interest. And then I think the hearing
Right, we
officer.
do read the comments that you bring in, but there can be, this is contrary to the proceeding, generally for a pre-hearing conference to invite these kinds of comments.
You have no idea what's in this paper.
I heard you read the first paragraph, ma'am. I have some understanding as to where you're going, and I've heard an
But-
objection.
But you
And
don't.
I'm going to grant that, objection.
Thank you.
Okay. That doesn't mean you can't submit it to me and I'll treat it as public comment, and I'll review it, or you can submit it, or you can also submit it as part of an intervention motion.
I'd like to get it to you sooner rather than later. How would you like me to do that?
You can hand it to me right now.
Well, I've written all over this one, so I'm happy to.
What you want to do then is send a public comment to the clerk of the board at the clerk of the board's email address, which I don't have in front of me. I do. She can be reached at psb.clerk@state.vt.us.
Okay. Could you repeat that? Okay, PSB.
.clerk@state.vt.us.
CLERCK?
CLERK
Okay, PSB.clerk.
@state.vt.us, and I think we also have new email addresses. I think hers is psb.clerk@vermont.gov.
Vermont spelled out?
Yes, ma'am.
I'll do that.
Thank you. With that, this hearing is adjourned.
Thank you.
Thank you.
Thank you.